All right, we're set for several bench trials this afternoon at 1:30 regarding tax sale matters. Do we have any that are uncontested? All right. Very good.
If I can point you through
Okay. Yes.
We have a signed settlement agreement with Attorney Douglas.
Okay. So Attorney Jones, you appear for Joan Johnson? Okay, and Attorney Megan Craig and John Craig appear for Alicia Jones. Right there on the table, sorry. Settlement reached and filed. Yes.
We also have one with American Rentals in Village Zones.
Okay, see that?
The terms literally within the last few minutes, so we could submit an order within the next 30 days.
Okay, settlement reached. Attorney Craig, you'll file the agreement within 30 days? Yes. And Attorney Jones, you appear for Village. All right.
And then I think the other one is United Nations Alliance and Schneider Grant Company.
Okay.
I think we got.
Attorney Golding, you appear for United Nations Alliance?
I do, Your Honor. I just want to review the record of the other belongs to all the
We're willing to stipulate for the cancellation of the micro. Basically, I support that we didn't do anything wrong, we did everything properly. We've got a lot of court costs that we shouldn't have taken on because of this decision. I don't know if the court can do anything about it.
Attorney Golding. Well, I know that in the past that's something that's been worked out. In some cases I've seen it, I don't know, has that been discussed with the county?
It has, but what's happened in the past, what's been doing, their remedy is less than they have.
Is there a distinction between whether it's an error that kind of would flow to the property owner as opposed to the auditor? I mean, is there a distinction there, or is it always flows to the property owner?
That's it.
Okay, what was the statute? is there any discussion as to respondent paying fees then? Any claim, what's the,
We're claiming against us.
I think that because it was an error, it was so much.
no, I was asking Attorney Golding, if in light of that statute, are you asking for fees from them or for them? Do I need to set it for the hearing or what?
Well, I think.
Okay. Yes.
Is it possible that instead of this being a cancellation, that if we grant them a 120-day redemption on the property, then that would give them 120 days to redeem it? And then we would be able to file at our attorney's office under 137Bs.
Yeah, that's exactly right.
Well, and I think that
There's no right.
137 because of the 4.5 noticing anyway, it doesn't allow for any further in other cases. In addition, that there was property that notice of all the fire service had canceled.
Okay, and that's what I thought I heard as the agreement. I just am unsure as to their request from attorneys fees, whether it's there. And this is the first time I've dealt with this issue because usually if there's a cancellation of pre-sale notice, in the past, the auditor's office, I believe, has usually paid the attorney's fees. Yeah. And that's a change in policy from the auditor's office? Or
So would we have a few other cases too, I gotta be honest.
well, I guess it just causes me a little pause simply because I'd like to see a bright line demarcation for the attorneys going forward to know what they're dealing with. But well, whatever you want. That's. Are you against them or against both of them?
No. We're addressing basic stipulation D, so we'd have to do.
Well, I understand what the stipulation is.
Well,
I'm just trying to clarify whether or not
I mean, the only thing I'm thinking, Your Honor,
they want fees from you
as far as I've heard,
or them or both. That's all.
There was one situation.
There was another time I did also. It was against the railroad. But I don't remember exactly why. But it was against the railroad, not against the auditor. And it was because the railroad had failed to adequately make sure their property was off the attachments, which I don't know if it would apply here or not. But that was my reasoning in that particular case. That's why I asked you. You asking it from them or from them? Okay, well, we can set that for further hearing. I just wanted to make sure because and I think you all know that I want to be consistent in my rulings. And the only reason, I'm pausing on this is because this hasn't come up before because normally it was.
It'll be coming up again, don't worry. I appreciate it.
No. Okay, so somebody clarify to me what we're doing here. Attorney Wiley? File that within 14 days. And your hearing. June 4th, 9:30. Oh, yes, I know you should, yeah, I didn't realize, yeah. Who did we set that for? You want to move it to 11? You want to move it to 11? Well, that's why we're discussing this. What about 11?
Well, Sean is around either, and around.
Yeah, that's fine, and you might want to call them, just tell them we had this discussion, and for scheduling purposes, nothing ex parte with regard to him, but just scheduling that we realized after, at the afternoon call that Attorney Wiley wouldn't be available for that June 4th at 9:30, but would be available at 11.
And I'm
How long is that going to take?
that one. Well, we estimated an hour. We haven't gotten to the back.
So we could piggyback this one
I
on.
would.
Okay.
Well, this don't need to be present for this one.
Well, no, but I think we
Well, no, I'm
have
gonna-
enough time between 11 and
Okay. Yes, it is.
June 4th at 11? You're welcome. All right, Attorney Golding, you have some other matters? And Attorney Smith, do you have any that are agreed to, or are they? Okay, you have 3 cases. I see 2 of them are together. And how long do you anticipate? Attorney Golding, what's your timetable on yours? You've got 2 with Dan Barnhart? Is that James Roy? Oh, okay.
Do my offer for Thursday.
Attorney Jones? Dan Barnhart and James Roy Jr. Estate, or Roy James, I don't know if this is... Okay, we'll continue those to tomorrow at 1:30. I am. No. Oh, I don't see any at 1:30. Do we? Oh, do we? Yeah, it looks like we do have some. Okay, so what should put? Well, let's do it at 11:30. I have you here at 11. I have you here at 11:30. On Charles Banks and Williams Banks. I don't see you at 11:30.
Well, that's the one that's.
Oh, okay, okay, that's why it's not, right, okay.
Here.
All right, yes. All right, so 4/23, 14 at 11:30. Yes? All right, so does that take care of you, both of you?
I need to get back to my box and call them.
Come back. All right, Attorney Smith? We'll take Juan Martinez first. Juan Martinez, since they've waited the longest, since they were here at 9:30.
Oh, is that right?
Martinez showed up this morning. Well, he was set for what?
4941 Bearing.
45-03-32-128-019.000-024. Yes?
Correct.
Attorney Smith appears for the City of East Chicago. You're Juan Martinez? And we're set for trial regarding a petition for tax deed. Are we ready to proceed?
City is, Your Honor.
Yes? Do you have an objection to the tax deed being issued? Oh, okay.
Your Honor, the city's position is they'd like to move forward with the tax deed and then once the deed is discussed. Continue the use of the property at this point. Concern that it doesn't
You understand that? That's basically what he just said. Well, basically what he just said was they would negotiate after the, yes?
I'm sorry, Your Honor. Yes, that's right. The city's position is like to obtain a deed. It is a vacant lot. It's in an area of redevelopment of the city, so it's trying to use these lots.
All right. Okay, so are you ready to proceed with the, Attorney Smith, do you have any evidence to present?
I do, Your Honor. Give a copy of what we're presenting. If I could throw it around to you for exhibit.
Yes.
Number one, certificate, number 451217562, and signed by the Commissioner of the City of Chicago on June 5th, 2013. As you can see by the exhibits, the 4.5 notice was mailed on September 2nd of 2013, which is well within requirement under 6-1.1-25-4.5 that it would be issued, that they would be sent by certified mail no longer than 90 days after. The certified mail cards are attached to sub 2 of Exhibit 1, as well as the service by publication. There's an affidavit of publication attached indicating one time a week, 3 consecutive weeks, all prior to the 90-day period prior to the 90-day after the period. That's Exhibit 3. Then Exhibit 4, of course, is the 4.6 notice that was filed along with the petition. The petition is file stamped on October 30th, 2013, which is on file more than 30 days prior to the hearing to allow objection. Obviously, Mr. Martinez had that notice and appeared at the objection hearing and objected. The Subexhibit 5 is the return receipt card of the 4.6 notice of petition, and of course, Exhibit 6 is the publication of that indication by the city to file the petition and of course follow the requirements of 4.6. 6-1.1-25-4.6. That is the evidence that the city would present to the court to comply with the statute and judgment of the overruled.
Any other evidence?
Nothing other than the already on record.
Do you have any objection to the admission of plaintiff's exhibits 1 through 6?
Obviously, it's not the time. We can't tell you. We can't. The clerk's office, our position is that unless the tax gets full, we want to proceed. But yeah, I mean, at this point, it's working position of the city.
Plaintiff's exhibits 1 through 6 are admitted. Okay. Petitioner Russ.
We do.
Mr. Martinez, do you have any evidence that you wish for the court to consider? No evidence? Attorney Wiley, any evidence? Any objection to the issuance of deed from the county's position? The question I had is there was a notice to Paul Shale.
Yeah, I believe that there were several ones.
Do you have a bankruptcy pending? Okay. All right. Based upon the acquiescence and the position whether the notices accepted, the court will grant the petition. Have you filed a form order?
I believe the order was filed at the date of objection was filed.
Anything else?
No, Your Honor. You want that filed?
If it's in the file, then. All right. Anything else? You can always contact the city now and see what the City v. Chicago versus Kimberly and Jeremy Rodriguez. City v. Chicago appears by Attorney Kevin Smith. Attorney Wiley appears with his representative Gina Scheit with the Lake County Auditor's Office. And are you Kimberly Rodriguez? Kimberly Rodriguez appears self-represented. Are you objecting to the issuance of a deed? Are you ready to proceed today with a hearing regarding the petition for deed and your objection thereto? Attorney Smith, do you have any evidence to present?
Property number 45-311-002.000-4. Within Group Exhibit 1, the city would request admission of Group Exhibit 1 with the following. For the record, the certificate was assigned to the city by the commissioners on June 5th, 2013. The 4.5 notice was mailed on April 27th of 13. Sub-Exhibit 1, the return receipt cards were signed and received by Mr. Rodriguez and others on or around September 9th, 2013. That's Sub-Exhibit 2. Proof of publication and affidavit of publication is Sub-Exhibit 3, showing that publication was effectuated 3 times, 1 week apart, all within the 90 days prior to, the 90 days after assignment of the certificate. The 4.6 legal notice was mailed on November 14, 2013. That's Sub-Exhibit 4. That was, of course, notice of the city's intent to file a petition. The petition was filed, action was reported on November 20th, 2013. Sub-Exhibit 5 is the return receipt cards of the 4.6 notice. And then finally, Sub-Exhibit 6, dated November 22nd, 2013, is the 4.6 publication affidavit of one time published pursuant to Indiana Code 6-1.1-25-4.6, all within, the notice, 4.6 notice, and the petition was on file greater than 30 days prior to the hearing to allow Ms. Rodriguez to object, which she did, and appeared at the objection hearing. She has received notice. We would request admission of Group Exhibit 1 as proof of the city's compliance with the tax deed statute and request that the objection be overruled and the tax deed be issued.
All right. Do you have any objection to plaintiff's Group Exhibit 1, which contains Exhibits 1 through 6? No. What he's saying, well, what are you saying there, Attorney Smith?
Yes, Your Honor. The 4.5 notice dated August 27, 2013.
As far as redemption,
Yeah, that it gives.
maybe I'm confused as to what her question was. What's your question again?
To redeem my property.
Okay.
If I may simply accept that notice, is there supposed to be 90 days?
Okay, go ahead.
Yes, Your Honor. I don't believe that's the way the statute reads. What the statute reads is the notice has to be given no longer than 90 days after the receipt of the certificate from the commissioners.
In many instances, it ends up being, what, about 30 days?
And just for the record, the letter was dated August 27th.
Because the whole time period, this was a commissioner cell,
That's correct.
it's 120 days, and the redemption notice has to go out within 90 days.
That's correct.
So if it, go ahead.
That's 40.
But her question is essentially, with regard to the commissioner's sale, was she supposed to have 90 days?
At the date she got their notice.
Correct. Well, I know it is, but that's her question. It works out to being the way the noticing is provided under the statute. And since the notice has to go out within 90 days, and the total period is 120, essentially you end up with about a 30-day window for the redemption. From that notice, I'm saying. From that notice of redemption, from the 4.5. Oh, absolutely. My question simply was, do you have any objection to these being admitted into evidence? That's where we're at right now. Okay. Plaintiffs Group 1, consisting of plaintiffs 1 through 6, is admitted. Attorney Smith, do you have any other evidence?
No, Your Honor, other than what's already.
Okay, so you rest? So they're done with their part of the case. Now it's your turn. Was this on the 2007 sale? And that was the,
Well, we got before, I believe. Yeah, we were looking at
Judge, I would mention it isn't a lot of pertinent home.
we were trying to say that they used some money. We could have spent money on the I understand that you're trying to help. But with that, that's my property. No. We have to, I could afford to send money and then we can stay in position. I would say that nothing. I would be right on track. For 2007, I was raising the children, giving back money to the pay. 2007, we actually had to set one. I have to accept it. I don't think it's fair that it's not allowed, safety allowed, in the past 7 years.
okay, what did you specifically try to do? Any cross-examination, was that it? Any cross-examination?
No,
Attorney Wiley, do you have any questions? Do you have any other evidence or anything else you want to submit to the court? All right, Attorney Wiley.
I know, Judge, just for the record, I want to let the court know. Ms. Rodriguez, very nice lady, had conversations both in and out of court, and I know that she has met with the mayor. And although it's a business court, indeed, the mayor has, and again, having it in the city hands is better than having to go back to the tax bill. That we don't know what the
Anything else? All right, court will take it under advisement and have an opportunity to look through the exhibits. You're welcome. City of East Chicago versus the State of Larry Jones, William Larry Jones and April Jones. Anybody here for the State of Jones? Attorney Smith represents the City of East Chicago. These are two companion parcels at 4503, 33, 129, 038.000-024 and 45-03-33-129, 039.000-024. Attorney Wiley appears on behalf of Lake County Auditor's Office with his representative, Ms. Shape. And you are April Jones. April Jones appears. And we're here for a trial regarding the petition for tax deed filed by the City of East Chicago, along with an objection thereto. Are you still objecting to the issuance of the deed? you ready to proceed? Attorney Smith?
Yes, Your Honor, I could, I just speak to Mr. Jones for the hearing. I'm unsure what the objection is, but we have to.
Well, okay, what is your objection?
In response, Your
Well,
Honor.
yeah, I can't speak to what the city would be willing to do, so Attorney Smith can speak to that.
The city's position isn't one that has anything to do with the payment. We're not going to tax time and profit. What's the city desire to impede? I would just comment that the unfortunate time that they have at this point in the city's position is to obtain the profit to allow for the back end.
With that, are you still objecting? Well, I don't know if there is or there isn't. If they have all their noticing in place and everybody, are you claiming there was a defective notice of some sort, or did you have some other defense to it? When did he pass? When was the cell? Very well. When was the treasurer cell? No, I understand.
August 27, 2012, I believe.
So the August 27, 2012, treasurer sale the property was. Commissioners got the tax lien that was assigned to the city of Chicago.
June 5th.
And I'm sorry, you said that the title owner of the property was William Jones. And he passed away when? Right. Attorney Smith, any evidence? Yes. Yeah. Which includes exhibits 1 through 6 of each.
Sub-exhibit 1.
Do you have any objection to the admission of these papers as exhibits? So group exhibit 1 consisting of exhibits 1 through 6 and regarding each parcel are admitted. Any additional evidence?
No.
Ms. Jones, do you have any evidence that you wish the court to hear, other than what you stated previously that that's your father? That your father passed away, I'm sorry to hear that, in April of 2011? All right, Attorney Wiley, any objection from the auditor's office or auditor's position? Anything else by any other party?
Your Honor, just to note that the city DPW notice also has a representative.
There wasn't a state open? When was that open? Where is that? All right, Court will take it on everybody's lip so I can look at the exhibits. Get something. You're welcome. TJM Real Estate Investments. Yes. Anybody here? TJM Real Estate Investments, Devin Jones by Jeff Jones. All right, is Attorney Rodriguez here? All right. Petitioner Felsden up here. Jeff Jones is self-represented. What do we know about this? What about here? Mr. Jones, are you objecting to the issuance of the tax deed? I don't have any position. He was here February 7th. And so is Attorney Rodriguez. From the restaurant, so. sure my court code, just says it in second district. That's it. All right, well, having received no evidence with regard to the petition for deed, we deny it. And so it's to file whatever they want to later. So their request is denied at this point in time. Yeah. File in 14 days. Jimmy Richardson and Benjamin Coleman. All right, you are. Okay, Jimmy Richardson appears. And you're Mr. Coleman? Now, hold on. Sorry about that. All right. Mr. Richardson, it's your position. Are you still wanting to move forward with it? And Mr. Coleman, you're objecting to the request for a deed. Are you still wishing to object? Mr. Richardson, now would be the time for you to submit to the court any evidence that you have.
No, it's not. I have the power.
Who's Benjamin Coleman Jr.? Is that your son or? Is there a reason why your son can't be here?
He's not able to be here. He's sick at this present. Plus, we have the LLC and the management general party. We have all we
Well, where's the is the property? Was the property held by the LLC? Was it held by?
It was previously in my name.
All right, Attorney Wiley, actually, I guess, Mr. Richardson, do you wish to move forward with Mr. Coleman being here on behalf of his son, or? Well, let me ask you, what's the sum and substance of your objection?
We did not receive proper notice.
Of what?
Effective.
Of which one? Of the treasurer, pre-sale notice of the treasurer sale or the 4.5 or 4. Is this a treasurer sale or commissioner sale? Well, I think there's one that's attached to the latest filing of Mr. Richardson, but I can't consider that unless and until it's admitted into evidence. You can't just file something and for the court to consider without the other side getting an opportunity. So at some point in time, you'd have to move to admit it as an exhibit in this hearing for the purposes of giving them an opportunity to object, and then the court an opportunity to make a ruling on that. My primary concern at this point is what to do with the fact that Mr. Coleman's not here, Coleman Jr. Go ahead.
Your Honor, we have this, I guess, your ruling has to do with the power of attorney. We have had for years of operating this business. And I said without receiving proper notice, and without documentation from the county, that's also closed all properties and under our name. We are important resources. Supposed to be transferred from the city to not and have it to the county. And for some reason, in the letter, there was an omission of the property. I guess they were dealing with Vincent R. Cole Jr. because,
All right, well, when can he be here?
well, I could probably have to
Because we really need, with you not being an attorney, he either needs to represent himself.
we could do that.
Otherwise, you know, people could sign in the power of attorney over anybody and have anybody come in and represent them. And if the power of attorney is not saying that you can be their attorney to court, it's saying that you can sign checks for them.
Well,
You could handle their, it's not allowed,
It's not allowed to
not, yes, you may. Okay, well, we can hash that out.
No, we didn't get any notices at all. The notices that we got, as I said, okay, but I have cancellation. That's signed by you. Yeah, no, that's true. And we have cancellations of non-deliverable items from July 8th, 2012, and also July 26th, 2012, that were undelivered. So there is documentation of what he referred to was the letter that I picked up at the post office.
I'll grant you a very brief continuance. He has to be here next time. But we're not going to drag this out. This has been dragged out long enough.
No intent. I would request at least 30 days for that.
How long is the hearing going to take? Go ahead. I'm going to give him a chance to have him in here, but it's going to be a very short window. Well, another couple of weeks isn't gonna. May 7th at 1:30?
7.
Yes. You are. I think. So am I. Okay. May 7th, 1:30. He'll need to be here or we'll proceed in his absence. Yep. All right, I think that concludes everything on my call. You folks back there, are you here for a court case? Excuse me? With you? Okay, all right. So there's not a difference? Okay, well, we'll see on May 7th. No, May 7th.